Welcome, Marie.
Hello everybody, it's Marie here. As you can see, I've set up my own firm called Consilia Legal LLP, and we specialise now in employment matters, and we also have another field in matrimonial. So that's what we do, based in Leeds in Park Square, but it's still the same people, so that's great. Anyway, moving on then, defending claims in the Employment Tribunal. So obviously you've seen the typo, it's not clams. We're looking today at the claim process. We're looking at what happens on the day of a tribunal. We're looking at common issues when you get a claim and when you're defending them, and also at the 10 top tips, which we'll probably pull out as we go through. But if you do have any queries, as Liz said, please ask me. Okay, so moving on then. Start at the beginning. I think that's the best way to deal with it. Some of this may be familiar to some or all of you. But what happens now? So basically, a claim is lodged in the Employment Tribunal. It used to be free. It's not free anymore. It's £250 to lodge most claims. It can be cheaper for basic contract claims. And there's also a £950 hearing fee that claimants have to consider. And in addition to that, before they can lodge the claim, they have to get in touch with early conciliation, and that's run by ACAS. Now, most claimants contact early conciliation themselves. It's mandatory, so whether they partake in any negotiations or settlement conversations is irrelevant. What they do have to do is at least log the claim with early conciliation. So the first tip for you there is that either party can start early conciliation. So start your defence early in any kind of claim. If you have an employee who leaves or is dismissed and you know they're particularly litigious and they have indicated that they may be bringing a claim in the Employment Tribunal, you don't have to wait for the employee to contact early conciliation. You can contact them yourself. If you do that, the trick there is that the clock doesn't stop running on the claimant's time to bring a claim. I won't go into early conciliation now, although you might want me to speak about that on a different webinar. But basically, if a claimant contacts early conciliation, it gives them extra time to lodge the claim. The clock on the time limits, which is normally 3 months less 1 day from the act of discrimination or from the date of dismissal, stops. So if you contact early conciliation as the employer first, the time frame doesn't stop. So if you want to sort of get in there first, you can. I've got very different views from very different clients on this. Some clients do take a proactive approach and others prefer to wait and see. In any event, if you are contacted, if a claimant contacts early conciliation and ACAS speak to you, that will be the first notification that you've got a claim coming through the Employment Tribunal system. You do not have to participate in the conciliation itself. You can accept the call or log the claim and simply advise the ACAS advisor that you don't wish to enter into any negotiations at this stage. That's sufficient. If you've got legal advisors who act on your behalf, which I'm sure most of you have, sometimes the legal advisors can deal with that for you early doors. So you can either deal with it yourself or you can send it straight through to your legals, but it's a relatively straightforward issue. And at the end of that, whether it's successful or if it's unsuccessful, we'll start with that first. The claimant simply gets a number to put in on their claim form, and they can't submit the claim form without that. Of course, if you are successful in resolving the matter before you receive a claim, that's brilliant. And in some smaller claims, I have found that this is happening. So if you've a simple contract claim for a couple of £100 or something along the lines of that you could probably stomach, you might well be advised to settle that via the early conciliation method. But do take your advice or consider your position carefully. Okay, after the claimant submits the ET1 then, you should receive a copy. So the claimant submits the ET1 online, then you receive a copy. Okay, this is where you start defending your claim properly. You receive the claim on step 3, and also along with that, there will be a notification date, i.e. the date that you're supposed to return your defence to the Employment Tribunal. It's normally 28 days from receipt of the claim. Get it diarised straight away. My view on this is if you are responding and you're responding online to the claim, make sure you respond well in advance to ensure that there are no issues with the response. It doesn't cost you to respond to the claim at the moment, which is something I think will probably be addressed in the future actually, so watch this space. But at the moment you submit your response and you can do that online and it's free. My tip for you here is that you speak to everybody involved upon receipt of the claim immediately. Look at the facts of the claim, gather as much information as you can, and make sure that you can respond as fully as possible if that's the way you want to deal with it. Some respondents simply submit a very standard response, which basically is a rejection of all claims, and that may well be your house style. In my experience, though, it leads to a faster conclusion to the matter if you can submit a very robust defence at early stages of the claim. And also, if you can have as much information there as possible. I say speak to everybody early doors because a lot of errors I see in the Employment Tribunal on behalf of respondents is that they respond at first instance and then latterly in the witness statement stage, the witness statements contradict what's in the response. So people have changed their mind or they've forgotten what they said. Now, if you've already taken statements as soon as you've received the claim, you can keep your case consistent in defending the claim. And it's these inconsistencies that ultimately lead to people being embarrassed in the tribunal or unnecessarily over cross-examined because they're unsure of the case. So take witness statements early doors and make sure you submit as full a defence as possible. Also at this stage, you'll probably receive now a date for the hearing and also details of any other case management orders. Diarise the case management orders, okay? So these might include schedules of loss, they might include hearing dates, they might include witness statements, and I'll come on to those in a minute. Okay, so at step 4, you've submitted your ET3, you've considered everything in that. I'll just, on the ET3, one thing that's always overlooked is time limits. So it may well be, and I see this in a lot of cases, that the claimant's claim is out of time. If that's the case, say so in your ET3. Think about when they left and when they submitted the claim. If you think if they've submitted a discrimination claim and the act of discrimination is more than 3 months before the claim is lodged, then they may well be out of the time on that. And a lot of discrimination claims I come across are out of time because people think it's from the date of dismissal, which sometimes it is, but often it's from the date of the last act of discrimination, and sometimes the dismissal is not an act of discrimination. So check out your timescales, and if you need to take advice, do that. Okay, you put your ET3 in online, as I've said. The next step, and the normal step in case management instructions, is that the claimant submits a schedule of loss. Now, this is where you can really get to grips with how much the individual is claiming against the company. Now, when you receive this schedule of loss, please do not take this at face value. I've acted for employers on a number of occasions who will look at the schedule and think, right, I'm defending this claim, the schedule is absolutely ridiculous, and there's nowhere to go with it. My view and my next tip for you is look at the schedule, go through it properly, and submit a counter schedule. So if you know that the claimant is overclaiming or if there are errors in the schedule, make this clear to the claimant straight away. If the claimant has claimed for ongoing losses of a year, but they've mitigated their loss and not set off mitigation, point this out. In other words, knock down the claim value as early in the process as you can. Put the claimant off. As soon as you can point out the decrease in the value of the claim, and also when you're doing that, respond perhaps with a without prejudice subject to costs letter, save us to costs letter, pointing out the weaknesses in the claimant's case. I find at this stage claimants then do tend to come to the table to negotiate, or they want to withdraw a claim, which if they have got a legitimate cost threat against them is the time that they should really do so. So do submit a counter schedule. Think about the weaknesses when you've got the response and the claim together, and point this out clearly to the claimant at an early stage. It shows that you're doing your bit, particularly if the claimant is self-represented, which, because of the introduction of fees, I'm coming across more and more. And also it does make you look reasonable in a tribunal if you do lose and you come to submissions on remedy. Okay, moving on then to step number 6. The next step after disclosure of the schedule of loss is generally that both parties disclose documents which are relevant to the claim. Disclose everything here. I'm sure probably most of you have had absolute nightmares with individuals making subject access requests under the Data Protection Act. And if you have, what you'll generally find, what I've found in serious litigation, is that if an employee knows a document exists in relation to the case and you don't disclose it, they will follow up with a subject access request, and it makes you look a bit daft. So if you have got any documents which are relevant, and I say whether it helps your argument, helps the other side's argument, and or is detrimental to the claim or to your defence, then disclose it now. Best that everybody's open from the outset of disclosure. And again, this is a step where individuals look to resolve matters, withdraw cases and or settle. Do disclose what you need to disclose. The next step in the proceedings is then that the respondent generally prepares a tribunal bundle. Now, my tip to you on this is make it clear, make sure the bundle is clear and legible, especially in Leeds, and I've been knocking around in Leeds for quite a while. They like to be able to get to the papers properly. Lever arch binders, clearly divided, clearly numbered and paginated properly. All bundles to be the same, so no documents missing out of any of the bundles. That irritates the judges, and for rightly or wrongly, it doesn't put you on the good footing with them. So make sure that all documents are clearly photocopied. I once had a claim where a chap had been sending pornographic emails to a particular staff member. I acted for a claimant back then, and the respondent prepared the bundle. The copies of the material, as I will call it, were particularly poor, and with good reason. They were totally offensive. But in the tribunal ended up being adjourned while the chap had to go off and get proper colour copies. So he'd have been better served just making a reasonable black and white copy at first instance. As it happens, obviously, he did lose the claim because you shouldn't send pornographic images to your staff members, but just a tip anyway. Right, so after the respondent has prepared the tribunal bundle, the next step is normally that both parties can submit a schedule of issues, and hopefully this can be agreed. It doesn't happen in every case, but sometimes it's useful so that before a hearing you can be absolutely clear about what the other side believes the issues in the case are. They might be completely different to what you believe they are. And then the next step, obviously, is to attend at the tribunal and a judgment, followed by any remedy hearing if the claimant is successful or appeal. Now, another tip I've got for you here is before you get to the tribunal, after you've dealt with the schedule of issues, and probably at a much earlier stage than this, when you receive the ET1, I'll just skip back to there. If there are any areas about which you are unclear, it is always wise to make a request for further and better particulars. So, for example, I've received many claims over the years where an individual will say, I have been discriminated against, full stop. Now, it is a very common practice for respondents to then think about and make a defence to a claim that has not been properly advanced. So if you think, oh, well, that particular individual thinks they've been discriminated against because they're a disabled person, and you respond on that basis, what you're actually doing is you're making the claimant's case for them. What you should be doing is saying, you think you've been discriminated against at paragraph 1 of your particulars. Can you please provide further details, including, and then gather all the information directly from the claimant. So, for example, on what grounds have you been discriminated against? What type of discrimination? What is the protected characteristic that you claim that you have? Make strong, further and better particular inquiries on every point that you're not sure about, and don't just automatically respond. Another issue in the response, if I'll skip back while I'm talking there, is if you do get a claim form, which is basically a 6-paragraph rant, and I've seen plenty of them recently, by the employee, don't be tempted to respond in the same way. You can do if you want and cite a chronology of events in response, or you can just simply defend the claim, and in my experience, just putting a simple defence in if you do get a rant which is unclear is probably the best way while you seek further and better particulars. Okay, so moving on then to what happens on the days of the tribunal. Now, if you do get to a tribunal, and I'll say that hesitating because Most cases still do settle, although at the moment, because the claimants are paying fees, it tends to be only the seriously litigious cases that are actually getting to a tribunal or being progressed. You can settle at any point via ACAS prior to the hearing, and normally it's the same ACAS representative that would have approached you during the process of early conciliation, which is quite good for continuity. If you're not able to settle or you're not minded to settle before then, you can still settle on the door of the tribunal. But remember, once fees have been incurred by the claimant, so if they've actually gone to a tribunal and incurred the £950 fee, they will be looking to recover this as part of any settlement, which they didn't used to before. So when you're looking at settlement, this £950 I think is a bit of a big thing to keep in mind, because the claimant's not likely to settle on the door without seeking some kind of recovery of that amount. When you get into the hearing, if you can't settle, then the process is normally as follows. So any outstanding issues are normally resolved at the start of the hearing. This is why it's really good to get a list of issues sorted out at the beginning. Witness statements are normally taken as read. So we used to, particularly in Leeds, we used to have all witness statements read out by the individual who had made the statement. But actually now the tribunal normally adjourn at the beginning of the day and read all the documents and the statements, so that the person who's given the statement doesn't have to read them out. They still do have to be cross-examined though, so if you or any of your colleagues do have to give a witness statement or have provided one, you still do need to attend. You still will need to swear to the swear as to the truth of the document and your evidence, and you will have to be available to be cross-examined on the evidence. And this is where I link back to the beginning of the ET3, which is about being prepared, having full facts when you do defend, if you're putting in a full defence to the claim. The downfalls in relation to defending claims, as far as I can see, are inconsistencies which are then pounced upon by good advocates in the tribunal and expanded to give an implication that you are in fact not telling the truth. And in fact, if you think about it, in a tribunal, the basis of most claims is who is believed. So is it the claimant? Is the claimant telling the truth, or are you? If your evidence is inconsistent, then the tribunal is more likely to believe the claimant, and vice versa. So that's the reason I would have gone back early doors to the claimant with any consistencies in their evidence as well. Anyway, moving on from then, once all parties have given evidence, and also you can be cross-examined by the panel or the judge, but in basic cases it's judges sitting alone now. It's quite an effective way of dealing with matters. Then both sides give a final submission, at the end of which there's either a judgment on the day, which is delivered verbally by the judge, or there's a reserved judgment. Now, if you fail in defending the claim, then there will be a remedy hearing. Another tip then in defending the claim early doors would be, if the claimant is alleging that they will not be able to work for 12 months, either because the job market is poor or because they are unwell or require a part-time job, there's lots of different arguments advanced as to this, then from the beginning of the claim, if I were acting on your behalf, I would ask you to gather together lists and lists of job adverts that the claimant could apply for if he or she were minded. So in other words, if you fail then in defending the claim and get to remedy, and you're looking at the amount that you need to pay the claimant, if the claimant says I couldn't work for 12 months, and then you can produce a lever arch binder of 300 jobs that the claimant could have applied for and did not, this is even better for defending on remedy. So not just defending the salient points, but trying to, again, to get the value of any claim down if you are unlucky enough to be at a remedy hearing. The claimant has a duty to mitigate from the date that they lose the position with the company and to find an alternative role, and they do generally provide a mitigation bundle, but you can provide a counter bundle, and that would be, in my opinion, absolutely crucial if you fail on defending for whatever reason and get to remedy. The other top tips here are, if you do think the claimant is responsible partly for their own dismissal or wholly for their own dismissal because of their behaviours, and this often happens, for example, if a claimant is dismissed on the spot, but actually their conduct just prior to the dismissal was so poor that you would have dismissed in any event had you followed a fair process. and if the claimant just then brings a claim saying, well, you didn't procedurally dismiss me correctly, you can reduce the damages down to nil if you could convince a tribunal that, but for the failure in process, if the process had been followed, you would still have dismissed. So, for example, in cases of assault, I had an example a few years ago where a client of mine took a bus full of their staff away on a Christmas party. On the way back, the bus erupted into a major brawl, and ultimately somebody got punched in the face and dismissed on the hard shoulder of the M1. Yes, technically there's a claim there. Yes, the person did bring a claim to say unfair dismissal, but we defended it. Arguably it was an unfair dismissal, but we got the damages right down on the basis that even if we had taken them back to work in January, we would still, on the basis of what happened that night, have dismissed. So that was a really valuable way to keep the judgment down. It's called a Polkey argument, and you might hear your lawyers referring to it quite often. The other element is contribution. So if somebody's contributed to their own downfall, which was another argument we used in that case, which was, actually they were 100% responsible because they shouldn't have punched that particular person in the face. The behaviour was completely unacceptable. So that should put it in some context for you. Okay, so moving on then, if I just whistle stop because I'm talking away, 90 to the dozen. But common issues and other issues that we look at is during the tribunal proceedings, and I often have this, I have clients who will say, look, Marie, I've started giving you everything, but actually there's other documents which I haven't disclosed. What do you suggest I do? Well, basically you should disclose them all the way through the hearing. So if you find that you've got documents, you're under a duty to disclose anything relevant up to the date of the hearing, and you may experience people making disclosures on the door of the hearing centre. You can object to that, but you should still make thorough searches and keep disclosing all the way through. Okay, what if you receive a notice of a hearing and you realise your key witness can't attend? Then you must immediately make an application to the tribunal and tell them that. If they're sympathetic to you and if it's a key witness, you'll then get a listing schedule sent through. So do make applications. You don't just have to turn up without your witnesses. I have had that on a couple of occasions, and it's totally unnecessary. Okay, if another common issue is that, say you get to a case management instruction that says you have to exchange documents or prepare a bundle at a certain time frame and you're not able to do with that. Or, for example, if you need to exchange witness statements and that person cannot provide the statement at the time required, then basically contact the tribunal, contact the other side, tell them that you're not ready. In my experience, when you're defending a claim, claimants tend to jump on little failures like dates that have been missed, even if it's, one day later or things not being sent in the post properly. So make sure you're clear with the tribunal all the way through and with the opponent, and try to comply with case management orders. But if you can't, make sure you say why you can't and be absolutely transparent. Okay, so my 10 top tips for defending claims are to take advice immediately, not just on receipt of the claim, but prior to receipt of the claim. It's always the case, and I mean, it's very rare that claims come out of the blue, and normally we've been advising our clients certainly on potentially litigious employees well before they're dismissed and also well before any claim is received. But take advice before and definitely immediately upon receipt of the claim. I say this because it may well be that we could get the claim struck out for you no problem early doors without significant expense. Or if you've got a really pragmatic advisor, often what we'll do is we'll sit down, look at the value of the claim, speak to the claimant beforehand and say, what is it that you want? And sometimes we can get rid of claims, and I've done this 3 times in the past 12 months before I've even had to go to the expense of drafting a defence. You can still settle at that stage. It saves the client a lot of money. It could save you a lot of time and costs. And ultimately, if the claim is low value or if you can speak to the claimant early doors, that does sometimes happen. As I've said, you could always contact ACAS first if you know something is coming so that it doesn't stop the clock for the claimant and it just gets things moving. It doesn't buy them any extra time. Gather all your relevant documents early doors and detail the reason behind everything in the grounds. Submit the ET3 in good time. That's my other tip. And where I've said it, I can't say this enough, but take witness statements as soon as you can while it's still fresh. There isn't as a delay now like there used to be in the tribunals, but goodness me, getting to the tribunal where somebody says, well, I can't remember, or, well, I assume that the lawyers told me to do that, is embarrassing. It does not sit well, and it will count against you in a tribunal hearing setting. Always consider making a commercial offer. I don't know if you have a de minimis, but maybe if you're in a team, you should discuss this. Is there a de minimis that you will not spend money on defending a claim? For example, if the claim is under £1,000, will you really defend that if it's actually more commercially savvy to make an offer? You can always make an offer subject to a settlement agreement or a COT 3, which ACAS can draft. It can have confidentiality and non-derogatory comments clauses in it. The COT 3 can be as complicated or as simple as you want to make it, but always consider making the offer. Always ensure your witnesses can attend the hearing. Always submit a sub-counter schedule of loss, and also, as I said, locate the job adverts in the papers online. You could use Liz for that, or anywhere else you can find adverts or information if necessary, if you do end up being at the point where you've failed to adequately defend the claim. Just one other thing I would say is when you're defending the claim, if you are actually drafting your own defence, number your paragraphs in the response form. It's really helpful in the tribunal hearing if you do get there, if you can refer back to sort of paragraph 1 in the ET3, paragraph 3. And when you're preparing witness statements, always number your witness statement paragraphs clearly. Try and keep it chronological as well, so it's easy to deal with. Also, when you're looking at your witness statements, cross-reference the bundle clearly, because all the documents that are referred to in the witness statements will probably be read. But if you've got a massive bundle of documents and you don't refer the tribunal to certain key documents, they may well be overlooked. So that's another issue you might want to consider if you do draft your own witness statements. Can't really think of any other top tips at the moment, but if you've had any particular issues and you want to ask any questions about anything that I might have missed or any particular issues that you've had, then let me know. I'm still here.
The previous question, just putting it on here, if you want to read it out, what is the impact on the number of ET claims?
Oh, the impact on the number of employment tribunal claims since the legislative changes and the in particular in relation to the fee introduction in relation to early conciliation is massive. I think in our area we're down about 70 to 80% on claims that were previously commenced. So the employment tribunals are at the moment quiet. I'd say I went to a talk the other day by the head of the employment tribunals in our region, and I think it's fair to say that from that I've gathered that most low-value claims have now disappeared altogether. The 1-hour hearings for breach of contract, they're just nowhere to be seen. So there's been a massive decrease in the number of claims, but the flip side to that is that the claims that are coming through are tending to be vigorously litigated. So maybe there's an argument to say that it's just knocked out the spurious claims. I think there is a fine line there, if you wanted my opinion on it. And if I were legislating for this, and depending on what government we get, I'd probably be suggesting that the fees are reduced to the maximum of a week's minimum wage to bring a claim, and also that both parties perhaps have to make a small payment to ensure that there's an access to justice. Saying that, the employers I'm acting for are at the moment absolutely thrilled that claims seem to be on the downturn. So I don't know what your experiences are, but that's ours anyway. Don't know if anybody's got any experience of this, whether you used to get a lot of claims and now you don't. Yeah, really quiet. Yeah. Okay. Well, you obviously don't. I'll pass you back to Liz. If you do want to get in touch with me, all my details are on the slides that will be forwarded to you. Happy to help in any way I can. And thank you for coming today. Thank you.
Thanks, Marie. Very good. There's a lot of information to take in there, isn't there? As I say, we'll send the recording and we'll send the slides over to you. So as we go forward, next week we've got volunteering as an employee development tool, and that's with a new partner, Michael Millward, and I'm sure there's going to be lots of useful information in there. It's got a quite interesting concept with the kind of experience that it's had as well. So please join us next week or any other webinars that you might feel of worthwhile for yourselves. And obviously give me some feedback, please, and let me know what you think. The numbers and everything and the links and everything are on the slides at the minute, so please get in touch and look forward to see you again soon. Thanks ever so much for listening today.